Okay, so today is a very important class because now we are going to start the actual contract clauses. So these are also known as um operative clauses and boilerplate clauses. So there is a basic the clauses that are going to affect the relationship of the transaction, the parties, and all that. So, what is expected out of this lesson is that after this session, you will be able to understand what we have to include in a scope clause, what should be the basic obligations or responsibilities of the parties. I have just included time as an essence of clause for some transactions. Then the important clause on price and payment terms. Then the validity of the contract, the termination or suspension clause. Uh, I'll also try to explain the difference between effective date and other dates of a contract and how we can avoid some mistakes relating to these. So, the first one is the scope clause. This is the most important clause of any contract as it contains the principal terms relating to the scope of service, supply of goods, or if there is any other transaction which is the subject matter of contract, then those terms. It may be covered as a statement or it may also be captured in an annexure to a contract. So there are different ways you can cover it, but since it is the most important one, so you have to have it in a particular clause contract. It will also include the respective parties' duties, roles, responsibilities relating to the work or supply of services, or let's say supply of manpower or material, and some technical details relating to the work. If it's a like a construction contract, then there may be information about what materials are going to be used in that construction, what type of specification of those construction materials should be of. Then there can be when these construction materials have to be supplied at the site and what will be the plan of construction. So, what period will be given for the supply, what period will be given for the construction, actual construction. There may be clauses on completion, tests, inspections. So there are different scenarios for different types of contracts. In a simple service contract, it may only include that the scope of services is XYZ. In a supply of goods, it will be like these types of goods have to be delivered. So there are different types of uh, expectations from a contract regarding the scope clause. Moving on, time as an essence is commonly found in a sale of goods contract when timely delivery is very essential, and if this obligation is not met, then it is considered as a violation of a condition of a contract. So basically, if this condition is not fulfilled, then the recipient of the service or the goods may consider this as a material breach and terminate the contract and recover damages also. So these type of clauses in addition to the sale of goods contract are also found in EPC contracts. So large ticket size contracts or construction contracts or EPC contracts, they involve huge amount of money, manpower, material. Therefore, timely performance is a key ingredient. But uh, there is a specific link of time as essence to the damages. So let's say if there is a, delay in completion or delay in delivery of goods, then there can be damages asked by the other party. It can be in form of liquidated damages. So if you get those liquidated damages because of delay, then time as an essence obligation is compensated by these damages. And since it has been compensated, then you may have to agree to an extension. So in EPC contracts, you will find clauses on time or the timely delivery or a delivery schedule, performance schedule, and then liquidated damages relating to non-performance, and clauses on what will happen in case there is a extension, time extension required, because let's say because of non-supply of goods or delay in supply of goods, an extension is required. So there are different scenarios which will be covered in this type of clause, and these will be linked with other clauses. So time as in essence has not to be considered as an isolation, but linked with the extension clause or LD clause, liquid damages clause. The price and payment term is also a very important clause which is extensively discussed. What will be the amount that will be paid for the goods or service or the works, how it will be calculated, uh, when it will be paid, uh, what will be included or excluded from the price, what will be the method of payment, what will be currency of payment. So there are different types of situations which can be covered in a price and payment term clause. There can be clauses on transactions relating to banking charges, who will bear it. There can be what will happen in case there is a payment delay. Then what are the pre-requirements for asking for payment? So like in EPC contract, you may have to submit some set of documents. You have to get a confirmation from the project director that the work has been properly executed, tested, and complied and accepted by the client. Then only the payment clause will trigger. Uh, there can be a situation where the parties may get into dispute relating to the payments. So, how that dispute will be resolved by the parties. So, clauses addressing these situations will be included in the contract. Moving on, there will be term termination and suspension clauses. These are also very important clauses because uh, sometimes you want to fix a responsibility on the other side to perform the contract in a timely manner. So you want to have the contract limited for a particular period. Or let's say if there is a recurring service, like let's say somebody is providing you on a daily basis some service, and that service you want to take only for a limited period because you expect that a competitive offer may come. So you may want to limit those services with an option to terminate the contract at easy terms, like just by giving a 30 days advance written notice. Uh, Termination clause may have different types of termination. One is termination for convenience, which is by simple notice, a written notice, for without giving any reasons and without incurring any losses, costs, damages because of those termination. Uh, then there can be termination for a material breach. Now, material breach can be of two types. One can be a material breach which can be cured and which cannot be cured. So, if a material breach can be cured, then a notice period is given, and within that period, the other party has to cure its breach. And if they fail, then contract is considered terminated. There can be situations of termination because of liquidation proceedings against a party, because of force measure, because of breach of law. So there are different circumstances depending on a transaction, depending on the parties, policies, requirements. So different situations will have different types of termination clauses. Similar to termination clauses, there may be a situation where you want to uh, hold or suspend a contract for a certain period because of certain reasons. For example, in IT contracts, it is common to ask for suspension to maintain the system for regular periodic maintenance, for upgrading the systems. So, in those situations, you may want to have a suspension clause. In EPC contracts, also suspension can be there. For example, if you are a contractor and your client is not providing the area for execution of the work, then you may want to have a suspension clause in your favor. Uh, let's say your client is a large project company which is constructing a project, you are a contractor, and your subcontractor uh, will end up suffering if your client suspends for XYZ reason, let's say for non supply of coal in a power project. Then, in that situation, your client may suspend, give you compensation for those period, or give you a time extension for that period. So similarly, you want to have a clause on a back-to-back basis with your subcontractor. There may be contracts where there may also be a consequence of termination. So, for example, if a termination is just for convenience, then how the parties are going to settle it? If it is because of a breach by the client, then how they are going to settle it? And if it is by because of breach of a contractor, then what will be the consequence of that? So those things have to be also captured. Next is, sorry about that. Just a second. I think that is all in this part. Okay. Now I have shared a document also, the lesson, which is a little bit detailed, and I hope that some of you may have gone through it. Even if you have not gone through it, that is all right. I'll just explain few things from the lesson for your understanding. Okay. So we discussed the scope clause, then we discussed what can be there in a scope clause. Now, a simple service agreement or a sale of goods agreement, what a clause will look like. So it will be like seller hereby agrees to sell and buyer agrees to buy the goods. The seller shall deliver the goods at the delivery location by the delivery date. So the key terms are the delivery location, the goods, and the delivery date, and the obligation on the seller to deliver the goods. The buyer shall pay the price of the goods upon delivery of the goods. So basically, buyer also has an obligation to pay the price. Now, let's say another example where it is a construction contract and the scope is included in an annexure to the agreement. So this is an annexure sample where it is agreed by the parties that contractor is going to perform certain works, which includes construction of the building as per drawings prepared by the client's architect and listed in another annexure. Another obligation to use the construction material of certain specification as listed in annexure C, which is also part of the contract. Complete the construction by, let's say, within X months from the date of signing of the agreement. Deploy sufficient number of skilled manpower required for construction. So it's a very simple way of drafting, but I hope you get an idea of what should be there in a scope clause. Now, coming to the roles and responsibilities. So, we all know that as a uh, lessee or lesser, there are certain obligations. So in a lease contract, so in a lease, the lessee will have some obligations like they will not use the premises for any business purpose. They will be responsible for carrying out minor repairs. They will not carry out any dangerous activity. They will not store any dangerous material in the premises. Uh, Likewise, in a license agreement, there can be a clauses specifying obligations of the licensee, like they are restricted to use the technology for manufacturing of the end product and nothing else. They will have responsibility to inform licensor about any breach of IPR in the technology. Now, coming to the technical standards that we referred, it can also be referred as a separate annexure. So, let's say in a EPC contract, there are certain designs or drawings or a technical specification. Those can be separately included in the contract as schedules. Next, we discuss the time as an essence contract. Now, I want you to read this particular para very carefully because we have to understand that even if a time as an essence clause is included in a contract, if the client has accepted the liquidated damages as compensation for that delay and timely performance has not been done by the contractor, then the obligation is satisfied by payment of that LD. And also, in view of the time extension clause, it has been held that time as essence contract, essence clause will not be binding on the contractor, where either the parties has agreed to a time extension or the contractor has paid the LD. So a justification or the compensation in terms of time extension or payment of LD reduces the value of the time as essence clause. Then coming to what will happen in case there is a failure to perform a contract in a fixed time. So this is the section 55 which talks about what will happen if it is uh, basically not performed in time. So when time is not essential, then what will be the consequence? And if there has been acceptance of performance by giving a time extension. So the law is developed through this section. So you can go through this part to understand it. Now, there are some recommendations for you. You can go through that. Going to price and payment. Now, the price and payment is a little bit contested clause in every contract, and it's most often pre-negotiated. So, as a contract drafter, you may get a fully agreed payment term, and you may have to watch out for the risk in, let's say, there is a non-performance or delay. So, is the client getting compensated for that? So all those things have to be washed out. But in principle, the amount, the method of calculation of the price, what is covered in the price, what is the manner and due date of payment, currency of payment, all those things have to be thought of. Now, this example 6 and 7. So, 6 is a simple one which simply says that if there is a performance of service by the service provider, then the customer has to pay a sum of X amount and it has to be paid by first week of each month for the services provided in the first month. Now, this payment is a monthly payment or yearly payment, that is not mentioned. So, it has to be also mentioned whether it is a monthly payment. So, this has to be said that the customer agrees to pay to service provider a sum of rupees X amount per month. Then there is example 7. So the first part is simply that the fees has to be paid at the rates and terms specified in a service schedule, and the undisputed payment has to be made in a specified currency as specified in the service schedule. So you may have a separate schedule for all the payment terms. Then who will be bearing the bank charges? So here the service recipient has to bear the bank charges. Then there can be other kinds of clauses like out of pocket expenses. Is the client agreeing to pay that? If he is agreeing, in what terms? If there is a transaction which involves provision of services by both sides and payment of money by both sides, so in those cases, whether there is a requirement of set off. For example, a client may have to pay some compensation for a delay caused by the client. Then clauses on delay interest, security deposit, taxes, etc. So, a cost or out of pocket expenses can be specifically included subject to a certain limit, or it can be uh, subject to documentary evidence of those expenses. A set off can be there in a agreement where both sides are providing services and receiving payments, or it can also be between a simple transaction of service by one party and payment by another party. uh, because there may be a situation where client may want to recover certain damages from the contractor, so that payment will be coming from the contractor. So in that case, client may want to have a set off clause that any amounts that is to be paid by the client can be set off against any dues or damages payable by the contractor. The delay interest clause is very interesting because it has to be a reasonable amount. It cannot be a unreasonable amount. So, depending on the context, for example, in international contracts, LIBOR, which is London Interbank Offered Rate, is commonly used. In case of Indian parties, it can be considered as a reasonable sum if 8% interest per annum is there. So we have to also think about those conditions, whether these are reasonable or unreasonable. So your role as a contract drafter would be to identify the transactions limitations, whether these interests can be held as a penalty instead of a reasonable interest. So whether the court will allow these charges in case of a dispute or not. So you have to think of that also. Then there can be a security deposit clause. So it is very common in the lease agreements to have a security deposit amount paid by the tenant. But whether that will bear any interest or not, whether there can be any deductions by the lessor in case of any damages towards unpaid utility charges and all, or towards unpaid rent. So all those clauses can be there. There can be a clause on credit approvals, like there can be a situation where a service provider is giving certain credit to the client up to certain limit, and beyond that credit, if the client breaches, then they may suspend the service. There can be clauses on taxation, which include a clause relating to TDS deduction. There can be a currency clause, especially in international contracts where the parties come from two different countries. Now, coming to the validity of a contract, there can be clause on simply like this contract is becoming effective from certain date and will remain valid for so many years, or it will be valid for a year and thereafter renew on year basis automatically. And there can be clause on termination. So there is some reading that you have to do in this lesson. I suggest you do that. uh, it is a very common situation where uh, retrospective application of agreement is valid or not, uh, that comes into mind or posed by the businesses. So yes, there can be a situation where you may have to agree to a written contract, making it retrospectively effective. So this is very common and accepted, provided there is actual transaction that was happening. But in some situations, you may want to avoid that. So, as a matter of policy, if you're in a house council, you should implement the policy that businesses should enter into a written contract before starting the work. Then these are some sample clauses on optional renewal or auto renewal. Then there can be termination clause, which we discussed. So these can be because of material breach, insolvency, inconvenience, uh, post major event, etc. So this is an example of termination for convenience and termination for material breach, termination for insolvency. Then there is a suspension clause. So I suggest you read these samples, and then there is consequence. So this is also a reading exercise for you. So in this particular lesson, uh, what we captured are the contract clauses which are quite essential for the performance of the contract. Now, by essential, I mean it doesn't matter that the other types of transaction clauses are not so important. They are equally important. Otherwise, they will not find a place in a contract. But they are categorized as a boilerplate because they are in any way there in a contract. Some of them may be very least likely to be contested. Some of them will be highly contested by the parties. So there are further categories of the boilerplate, which is a important category or a non-important category. So sometimes you will find it very interesting that the other side is negotiating on a not so important clause, and you may take advantage of that situation because there may be a situation that the other side will be giving the importance to a non-important clause for you, but they are giving that importance because of some past experience that they may have faced. So, as a contract drafter, it is important that you also ask questions and understand what those experiences were. So, you may understand the risk of agreeing to a boilerplate clause without negotiating on it or without having it in a favorable way. So that is all from my side on the lesson part. Now, before I move to next part, if any one of you have any questions that we'll discuss now. So starting with Anshu, do you have any questions?
No, sir, nothing.
Okay. Aarti ji, do you have any questions? Aarti ji, do you have any questions?
Uh,
Yeah.
yes, sir, I do have, but sir, can I ask in the like at last,
Sure, sure. No
at the
problem.
end? Yeah,
Okay, fine.
thank you
I'll
so
move
much.
on then to Govindji. Do you have any questions? Govindji, you do not ask any questions, you don't speak. It is all right.
Not, sir, not right now, but I will ask later.
Sure, sure. Prathamji, any questions?
I want to know what is an EPC contract, sir, and
Ah, okay. So
suspension clause.
EPC is engineering, procurement, and construction contract. So basically, when a client is building a project, a very large project like a, let's say, a power plant, then they may hire a main contractor who will be responsible for doing entire engineering. So engineering means putting things in place based on design and drawings. So they may also create those drawings, so client may provide those design drawings, and based on that design drawing, they will do the engineering of the project. After the engineering, they will procure the material for the construction based on the design and drawings. So there may be approval process for design drawings. There may be sourcing of materials. There may be because of the changes in design drawing, the quantity or quality or make of a material may change. So there may be clauses relating to that. Then there is a construction plan that the contract has to be performed in a timely manner. The entire construction has to be completed. then there may be testing or inspection by the client, then there will be pre-operational testing, a I think test start of the power plant, and when everything is approved, then there will be some small work that is left over. So major obligations have been completed, client has approved, power is being generated, then the major payment of the contractor will get released and some payment will be withheld. There may be also clauses relating to post-construction warranty on those materials, designs, drawings, engineering works, all those things. So it's a very complex contract, uh, quite negotiated. The easiest way to understand about it is to actually experience a contract while it is being drafted. Or you can start at this stage, you can start by checking out some templates of EPC contracts of different types of projects which are easily available on Google. So you just do a Google search for a contract of NTPC, NHAI, or other power plant projects. So you may get to have some publicly available contracts. They may not contain the technical side of the discussions, but they may have the contract clauses. So there's a tender process. After the successful bidding, a contractor is selected, they have to submit some advance payment bank guarantees. Then there is a plan that is agreed regarding the design drawing, manpower deployment, and all those things. Then there is construction schedule that is agreed. So all those things are there in the contract. So I suggest you start reading these types of contracts to get the larger picture of how these contracts, a complex contract, will be executed. Okay. Next, did I miss someone? Nosheen, do you have any questions?
No, sir, I don't.
Okay. Shadab, do you have any questions?
No, sir.
Great. So all of you don't have many questions. That's very interesting because this is the most important lesson, which will be, I think, the main area of work that you will always be doing. Anyways, so
So,
yeah,
yeah, now I would like to ask my questions.
please.
Okay, so today since we discussed boilerplate, actually, first of all, I would like to apologize again. Um, I was driving all the time because one of my close family member is in hospital.
Oh, so sorry to
Just
hear.
got discharged. Yeah, just
Okay,
got discharged. So I thought, okay, I should not miss the class. I joined the class via phone, and then so
okay,
I was not like
okay.
100% again. Like
No
I'm sure
problem.
from next class onwards, I'll be hundred
It's
percent.
all right.
Um,
Aarti ji, basically, we did not discuss the boilerplate clauses. We discussed the uh, clauses which are known as the commercial clauses, the scope of the transaction, the payment terms, price, termination. So these are some of the important clauses that parties discuss, and these are discussed by the business side of the transaction. And you may get a summary, or you may have to understand from the business side if the transaction is complex. Some things are pre-built, so some things are easy to understand. But if it is a complex transaction, you also need to have an understanding of the business, how a particular business functions. So if you're working in an IT industry, you will have a different set of requirement. If you are working in a power sector, you will have a different set of understanding. So understanding a business is also a requirement of a contract drafter. So do you have any other question?
yes.
Hmm,
So like, uh, for scope, when
hmm,
we like for the scope clause,
hmm.
so is it good to keep it brief, like crisp and short, or is it which one? Like what is better? Have
If
like
if your
low
client
level.
is if your client is the service provider or the person who has to perform the works, or if they have to deliver the goods, then they should have a clear idea of the scope. It should be limited to what is written down. There should not be something additional what is not there on the contract. So even if it is a detailed scope of contract, it is in the interest of the contractor or the service provider to have it written down and be limited to that. So there may be some additional wordings like if there is anything extra that has to be done beyond the scope, then parties will negotiate separately regarding the terms of performance, payments, and all that. So as a contractor, you may want to have that. As a client, you may have a different perspective. So you may say that this is the scope, but if there is anything related that is necessary for performance of the scope, then that is already included in the contract and you will pay a fixed price. You won't pay anything extra for that additional work. So it is always a contest, especially in large transactions. So in large transactions, if you find such a clause, you have to think about it if you are representing a contractor, and you have to think about it if you are representing a client. In small contracts like delivery of service or delivery of works, performance of works or delivery of goods, the scope can be limited to few sentences at max, or maybe to a separate schedule, one page schedule. But what has to be there, what doesn't have to be there, is something that the business decides. And most often, business is not so prudent to think of every situation. So, as a in-house counsel or a contract drafter, you may have to add few things or discuss with your client and explain to them the risk of what they are missing or what they should include, or what if they are including something that should not be there. So it comes from experience, it comes based on the business requirement, it comes depending on the transaction. So how you're going to write it will definitely depend on that. To uh, get an idea of how to do that, you can refer to some publicly available contracts. So there is a website onecle.com that may help you a lot. There are a lot many contract samples, although these are executed outside India, but you may get a good idea from what has to be there in a contract, what should not be there.
All right.
Okay,
Okay.
so yeah, sorry.
Now I have another question.
Hmm.
Okay. So since we were discussing like about payment terms, so are we going to discuss in terms and all in detail?
No, I'm not going to discuss Incoterms. Uh, I suggest that in case you want to know about Incoterms, it's easy to refer to the books relating to that. There is a blue book, I think. I have not
Okay,
read it.
Blue Book of Drafting.
Yeah, I'll check out and I'll let you know what book is that. So I'll share the link with everyone. Uh, but starts with simple concepts like what are Incoterms, what is the latest version, uh, what happens in case Incoterm is uh, relating to, let's say, if there is a delivery term. So how different is those in two different types of Incoterms? Who takes responsibility for payment of customs duty? Who takes responsibility for insurance, depending on what Incoterms has been agreed? So, especially in international contracts, it's very, very relevant. So, I'm not an expert in Incoterms, so I'm not going to teach that. But yes, you can learn through various sources on Incoterms. Anything else?
Yeah. Actually, I have a lot of questions. And I generally like. most of the time I'll get confused with like they like every contract. So there are couple of mandatory clauses, okay, which should be there,
Mm-hmm.
and there are clauses which, for some clauses, are very very important. But however, for some other agreements, they are not important. Like we can skip those.
Mm-hmm.
So like while when I review them, that time I don't like if they are already written, they are already present. That time I'm not like I don't face any challenge to review those kind of contracts and redline those clauses. But whenever like I need to, if I have to add it, like if it is not present and then I have to add it, so I like most of the time I miss those clauses which are not so common.
Mm-hmm. Okay.
Like
So
this.
I understand your problem. So basically, you're saying that uh, if there is a clause that you think should be there in a particular contract
Mm-hmm.
and it is not there, then you are undecided whether to include it or not,
Yeah.
and what will be the reaction of other side. Okay.
Mm-hmm.
So safer way is to refer to some sample contracts of similar transactions, okay, from publicly available sources. So you'll get an idea whether a similar transaction is using the clauses that you're thinking to include. Okay.
Mm-hmm.
Second, you have to think about the transaction, whether this transaction requires this clause or not, or whether you can do away with it. Do away with it, not legally, but as a overall picture. So there may be some interrelated provision which is giving you enough protection. For example, if you want to include a clause on termination of the contract because of breach of applicable law, okay, you want to have a specific provision on that. But you have a clause which says in case of material breach, and you have an obligation that parties are expected to comply with applicable laws. So generally you are covering it, but specifically you are not covering that. So in that situation, you may do away with the specific clause. Then you have to think about how your client will be protected. Now, for example, there is an obligation that the parties will comply with applicable laws, but the transaction is such that the other side is expected to deploy their manpower who are not very educated or are of workman category, and those workmen will be performing the contract, and you don't want to put a risk of litigation, so you may want to have a clause on the contractor having a contract labor license. You may want to have a clause like they will be responsible for paying PF, ESI dues on time, submission of the records to the client on time or by certain due date before, and make that conditional for release of payment, inspection by you, or obligation to maintain records. So there are different things that you can think of. And as a lawyer, if you think it is something that legally should be there to protect your client, then you must include it and argue for it in case any counter view comes from the other side, and negotiate for its inclusion. Sometimes you may be a weaker party, so you may not get what you want, but you may get something a simpler version of the clause that you want, or an alternate version, or a different version. So, how to protect it, that you have to think, and what to include, what not to include, you have to think as a lawyer, as a contract draft. As a lawyer, you may want to include everything, but as a contract drafter, you have the freedom to choose what to include and not to include. And you have to always think in terms of why you want to include it. Then you have to think what should be there, what should not be there, if you are including it or excluding it. Then how to draft that. So these simple questions, why, how, what, will help you get to your result. lawyer's work is always of thinking, analyzing, and then coming to a conclusion. So, having an analytic mind will be very helpful. So, practice that. And how to practice that is by learning about uh, similar types of transactions, learning about from different sources like there is a very good source, Mondac and Lexology. Then there are some uh, law firms who are publishing good posts relating to these. There is a law firm, Indian law firm, Nishit Desai. They publish good research paper on almost every larger issue. So they have good one on damages. They have good one on other areas like insolvency. So you can check out their websites to get a larger picture. You can search for your specific issue in a Mondac or Lexology website. You can find some sample contracts by searching, doing a Google search. Then you will have a good understanding. And uh, it comes from experience also. For example, uh, you may be including everything in a contract and getting your way around it by having a, let's say, you have a larger negotiating power, so you get around your counterparties to agree to it. But it may happen that even if your counterparty is a service provider or a contractor, uh, they may be an MNC. In that case, you may have to think very logically. You may not be able to convince them. So you may sometimes have to accept the counter view also. So have that open mind also. Sometimes it's commercial risk also. So if you think it is something that management can take a decision on, because management doesn't want to lose the business. So from that point of view also you have to consider. Should we move now?
Yeah,
Okay.
sure. Thank you,
So
sir.
it's okay. Uh, what I wanted to do was start the drafting. Okay. To get a picture of how you all are, mm, I mean, how good you are at writing. Okay. So to do that, I'll just share a link with you. Please open it. Just a second. Give me 1 minute. I hope everyone is on uh, desktop. If any was in on mobile, just let me know.
Yes, sir, I was using phone.
Okay, so please come on desktop if it is available.
Okay, sir.
So let me know once everyone has joined. Okay, so everyone is there. So I think Aarti ji and Pratap ji, you both are an experienced drafter, right? I mean, you're currently working in some organization or doing practice. So you have an experience in drafting, right?
Yes, sir.
Prathamji, am I right?
No, sir, I'm just in my final year right now.
Okay.
So
Govindji, how
I've
about
just
you?
I am also a beginner, sir.
Beginner. Okay. Anshuji, how about you?
So even I'm studying now in my final year.
Noshinji, how about you?
Even I'm a beginner, sir.
Okay, great. So all of you, except for Aarti ji, uh, please write your name anywhere, okay, in this document. And after that, draft a scope clause for a transaction which is about uh, delivery of service. The service is provision of consultancy by the service provider to a client XYZ. And in this particular clause, you have to capture uh, what that consultancy is all about. So it cannot just be said that we are going to give you consultancy. It has to be a consultancy about something. So before you start writing, uh, you have to organize your thought and think what type of consultancy the service provider is giving. Then after you have completed the scope clause, uh, then you write uh, about the term clause, and you can be wrong. It is all right to be wrong. So without any fear that you are committing mistake, write whatever you can think of, but organize your thoughts, then write it. Then it will help, and I'll help you revise that. So starting with Noshin, I have just, hopefully
Yes,
my
sir.
spelling is right. Just
Oh, you
below
can
this
correct it.
line, yeah, you can correct it. Below this line, you just write your scope clause and then the term clause of the service agreement. And all of you can just start writing after writing your name. Aarti ji,
Yes, sir.
I suggest you write a uh, termination of breach, um, termination clause for material breach.
All right, sir. Sure.
Okay.
Hello. So can
So,
you just repeat that what like in scope clause we have to write related to what? I missed on that.
Provision of consultancy service. Think what type of consultancy service it is. Okay, will it be a consultancy regarding a project? It can be a consultancy on some technology. It can be a consultancy of anything that you can think of. So the first statement can be that the service provider has agreed to provide the consultancy service. But I want you to think of the scope clause. What all should be there as part of consultancy service? What should be there in a scope? So think about specifics of that scope clause.
All right, sir. Thank you.
So could you please share the link?
It's in the chat in the meet. Go to the chat section. Govindji, Pratabji, hopefully you got it.
Somehow I'm not getting any messages like.
In the meet.
Yeah.
Hmm. Okay. Then let me share this document with you. Your email ID is ARTIE.
CS. Yes.
Okay. So check your mail. It should be there.
Yeah, just got it.
Don't worry about spelling mistakes. Worry about what should be there in the scope. I'll give you guys 10 minutes. Krati Gautam, am I saying your name right?
Yes, sir.
So I'm sorry you missed
I'm
the entire session. We are on
Yes.
the exercise part, but
Okay, sir.
you can get the recording of today's session later. And meanwhile, we are working on the actual drafting, so you can just watch the screen that is there.
Yes, yes.
And so just let me know, do you have some experience in drafting?
Yes, a little bit.
A little bit by mean, are you working as a lawyer or contract drafter?
Yes.
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 Okay, great. So we just discussed the scope clause, the payment terms, the term termination, and all that.
Yes, yes,
So if
yes.
you have seen the lesson, so you may not have missed much. It is there
Yes.
in the PDF file that I shared. So you can go through
Okay.
that. You can also watch the video for if you don't have time to read.
Yes, yes.
Uh, and if you want to participate in today's exercise, there is a link in the chat box. You can go to that, open the file, and since you're experienced, I want you to write a clause on termination for convenience. Just a simple
Okay.
clause on termination for convenience, and just think before you write
Okay.
because there are others who may learn from you.
Okay, sir.
Okay, thank you. So, Noshi, Nanshu, Pratham, uh, do also write the term clause. If I missed anyone, Shadab, right? 10 minute. Anshuji, are you stuck?
Sir, I'm not able to think about what does a consultancy firm actually does.
Okay, I'll help you. So think of a consultant who is uh, hiring somebody on behalf of a company. So there are HR consultants, and they interview the prospects. They schedule the meeting with the client, the company. They also negotiate on the expectations of the uh, I mean the employee, prospective employee. But always remember that they are the counterparty to the client. So they do not have much obligations to the expectant employee. Okay, from that point of view, think of few pointers what the client must ask the consultant to do.
Okay, sir.
Okay. Anybody else needs help? I only see Noshin, Anshu, Pratham, and Arti. Govindji, are you writing? Shadab,
Sir, I'm thinking of what can I write. I don't understand actually.
it's all right. If you have any issues from that perspective, I understand. Idea is not to compel you. Idea is to
Yeah, I understand, sir.
I just want you
Now I
to
am getting it, sir. How can I proceed and how can I approach this?
yes. So idea is that you learn maybe from me, maybe from others, maybe from some external sources, but idea is that you learn. So it's just not putting things on paper, it's how you put things on paper. Anyways,
So,
yeah.
sir, please then um, provide me a hypothetical situation where I am supposed to write a clause like this, I can
I think the
describe.
HR consultant example is good one. It's a easy one. As an HR consultant, they are expected to do few things like they have to arrange for, I mean, find out the relevant employees who may be interested in joining. Then they may be uh, asking few questions from them. So basically, they have to organize a meeting. They have to identify that they are qualified for the advertised job or not. And after the meeting is successful with the client, if the client decides to maybe hire the employee, then there may be some post hiring engagements also, like collection of documents.
I don't understand, sir. I'm not getting this, sir.
Okay, all right. So I'll explain if somebody does that, then I'll explain.
No, I
Govind.
don't. What
Mm-hmm.
what I mean to say is, sir,
Hmm.
that the contract should be on behalf of my employer who recruits other employees, and
No, no,
so
no.
I should.
See, if I am a company, then I may not have the time to find the, and I have a job opening, then I may not have a time for finding out the right candidate. So I may approach Naukri.com. I may approach independent HR consultants and ask them to do the search, the executive search. So they will find the relevant person who has the relevant experience. Then they will ask questions. You may be getting calls like, "Are you interested in this job opportunity? So this is this role. It is this work that you have to do, and what is your expectation of salary?" So identification of right candidate. Then
So this contract is about the supply of service by SR consultant and company.
yes, it's a contract between HR consultant and company.
Okay, sir.
Yeah. Govindji, any issues?
No, sir. I just try,
Okay,
and after that,
sure. So I think anyone else has any question?
Sir, I think I have written it in the message box.
Oh,
I didn't find the link for the Google Docs,
hmm.
so I have written my answer in the message box.
You did not find it? Okay.
No, no, actually, the previous messages are not shown. That's why it
Acha.
might have
Okay,
lost.
maybe you joined a different session. Just a second. Let me share that with you. So in the chat box, I've just shared the link. Can you see? Is it visible? Copy. So I'll just write on your behalf.
So I'm done.
Just a second. Let others finish also. 5 minutes more, then we can just stop and discuss. 2 more minutes. Please complete.